hearing in Appeal Mohammed and others, and the Ministry of Defence and another.
Before we start, I should just make it plain that we are ordering that no one should publish the names or addresses of the respondents known as XYZ, ZMS and HTS involved in these proceedings, or should publish or reveal any information which would be likely to lead to their identification or to any member of their families in connection with these proceedings. Copies of the order, if anyone's in any doubt, are available. Mr. Eadie.
Good morning. Round 2, Crown Act of State.
Yep.
And only Crown Act of State. I think you've been subjected to a flurry of recent documentation on other related issues in relation to German law and French law, and I think yesterday or on Friday some more submissions from the other side on some of the procedural aspects of Article 5. I think we're concerned with any of that. Today is a narrow, albeit not wholly straightforward, set of issues around the existence and nature, if it exists, of Crown Act of State. I'm assuming that, my Lord, I can be forgiven for not reading out the cast list of those who appear before you. They're tolerably familiar.
Yes,
and in
they're
the
all very welcome, and we know who they are. We know who you are.
Well, and running order too.
Absolutely. We have the running order. Thank you very much.
Good. By way of brief introduction...
Well, we don't know how the respondents are dividing matters between them, but no doubt we'll be told.
No doubt we'll be told, or no doubt we'll find out in due course. By way of introduction, and to point you in the way of those parts of the court's judgments below which deal with the facts, Serdar Mohammed, Mr. Justice Leggett, his judgment is in the core volume, if I could invite you to take that up, at MS page 6266, if you're on the electronics. And if you go to paragraph 13 of that judgment, at 6276, you will see the preliminary issue as it originally was, or the set of preliminary issues as they originally were, and you will see, so far as relevant to today's appeal, paragraph 1 of the preliminary issues that are quoted in para 13. That has now shrunk, effectively. No one is now arguing that Crown Act of State operates to preclude a claim under Article 5 of the Human Rights Act. And you know, just by way of putting it in brackets next door to what is not as part of the preliminary issues, that the government does not rely upon Crown Act of State to defeat the claims that were made by Serdar Mohammed that he was mistreated by British soldiers on capture. So the preliminary issue, so far as he is concerned, is about and only about his claim for damages for false imprisonment, the tortious claim in that regard. The facts that form the base, or the basis for that preliminary issue, you see summarised in paragraph 10 of Mr. Justice Leggett's judgment, 6274 in the electronic numbering.
Yes.
And the reasons for those, rather unusually being the facts, effectively taken from our defence rather than their claim, the reason for them being set up in that way you see explained at paragraphs 11 and 12 in Mr. Justice Leggett's judgment.
Thank you.
And for good measure in our case, if you're still on the facts of Serdar Mohammed, which I know will be very familiar to at least some members of the court, you see those also summarised. I'm not going to invite you to turn it up now, but in our case, at paragraphs 10 through to the end of paragraph 14, a single page, 12175 in the electronic. But as you there see, and as some of you will, I'm sure, be very familiar with, he was believed to be a Taliban commander. He was picked up in Afghanistan in the early hours of the 7th of April 2010. He was then held in custody by British forces before being transferred back, about 3.5 months of detention, before being transferred back to the Afghan authorities who then prosecuted him successfully, and he was convicted and sentenced to a prolonged period of imprisonment. That's by and large the guts of the facts as far as he's concerned. So that's the Sardar Mohammed preliminary issue. A further set of preliminary issues also raising Crown Act of State were raised in the combined claims, as it were, that were dealt with together by Mr. Justice Leggett in a separate judgment some months afterwards in the Rahmatullah case. His judgment in that case, again, I'm simply introducing the paragraphs of his judgment which show you the nature of the facts and the preliminary issue. His judgment in that case is in the core bundle starting at page 8080 in the electronic. And he dealt, so far as Rahmatullah is concerned, with the preliminary issue that arose in his case at paragraph 7 on page 8085. And it's the second of those preliminary issues quoted in paragraph 2 within paragraph 7 on page 8085 that is the Rahmatullah preliminary issue.
Yeah.
So that one deals with the tort of false imprisonment. The facts on which Mr. Rahmatullah's case proceeds for this purpose were summarised by Mr. Justice Leggett at paragraphs 1 to 4 in that judgment. Again, I'm not inviting you to read that all through now, but you get the essence of it really from the first sentence of paragraph 1 and then paragraph 4. So a very short period. We're in Iraq in the case of Mr. Rahmatullah, a very short period in British custody, followed by a transfer to the Americans, where he was then held by the Americans for a prolonged period. And again, members of the court will be familiar with Mr. Rahmatullah's base case. He was the man who led to the habeas corpus claim that went to this court in the Rahmatullah decision there. So those are the base facts. If you go forward still on Rahmatullah to the claims that are being made, we've reverted to the usual rule in relation to his claims. See paragraph 21 of the judgment on 8089. And the claims that he makes, the tortious claims that he makes, are summarised in paragraph 22. And as the learned judge then records in paragraph 29, in this case, no defence has yet been served. And again, just for your note, if you want another summary of the facts of Rahmatullah's case, in our case, paragraphs 15 to 21, our case for this appeal, paragraphs 15 to 21. But you will recall that in this judgment, Mr. Justice Leggett also dealt with a number of test cases of which the lettered claims are examples of a large number of claims that have been brought against the government in the context of the military operations in Iraq. Those are the Iraqi civilian claims. The preliminary issues that were ordered in relation to them, you see in paragraph 11 of Mr. Justice Leggett's judgment, if you're still there, page 8086. And it's preliminary issue number 2 that is the relevant one for our purpose. And so you see encapsulated in that preliminary issue the additional issue of transfer, if I can put it that way. So you've got the tortious claims based on detention, and you've got the tortious claims based on transfer in those cases. And the relevant summary of facts, so far as those cases are concerned, you get from paragraphs 13, 14, and 15 in Mr. Justice Leggett's judgment, setting out the nature of the claims and the allegations that are made. So those are the preliminary issues, and those are the base facts that frame the issue of principle that arises before you. Can I just refer you to the reasoning of the courts below, so far as relevant to the issue that you have to confront today? Go back, if you would, to the Sardar Mohammed judgment, Mr. Justice Leggett, beginning at 6266. And his reasoning on the Crown Act of State issues begins at paragraph 358 on MS 6367. And the part of the judgment with which we're concerned is paragraph 358 through to the end of paragraph 408. I'm sure you've already identified those as the relevant paragraphs, but just for the note in the record, that's where they are. And those are really the only bits of that judgment that one is concerned with. In his judgment in Rahmatullah, or more accurately, Rahmatullah and the Iraqi civilian claims,
358.
So that's where he deals with the Sardar Mohammed one, 358 to 408 are the paragraphs. And then we've summarised his Sardar Mohammed reasoning in our case at paragraph 31, 12,180 of the page number for that paragraph, into his judgment in Rahmatullah and the Iraqi civilian litigation. And that begins, as you know, in the core volume at 8080. But so far as that is concerned, he deals with Crown Act of State, beginning at paragraph 179 on page 8129. So his core reasoning, effectively adopting the reasoning, or his earlier reasoning in Sardar Mohammed, this case coming a few months thereafter, but with a bit of a tweak, which I'll come back to say he might prefer to analyse things as a defence to a claim in tort rather than non-justiciability. I'll come back to explain that, but the relevant paragraphs are 179 to 226.
179.
179 to 226. 179 is on page 8129. Sorry to swamp you with numbers, but 179 to 226 are the paragraph numbers.
Thank you.
You see just below the heading Crown Act of State and following. And again, we've summarised his reasoning in that judgment in our case at paragraph 34.
Thank you.
His order, that's Mr. Justice Leggett's order in Rahmatullah, if you go back in the bundle to 8067, you'll see the order that he made in the Rahmatullah case, so far as Crown Act of State is concerned, at paragraph 3. So you'll see that was effectively reflecting the fact that we hadn't yet pleaded, but he set the principles and then said, well, if that's made out, then Crown Act of State applies. But that's the order in Rahmatullah. If you go a few pages on to 8072...
What's meant by lawful UK policy? Lawful under which law?
Yes, I'm not sure quite what that refers to. I mean, I think in his judgment it's put on the basis it's deliberate UK policy.
Yes. Yes,
It might be rather question begging to ask which particular system of law.
Well, it could be deliberately unlawful, of course, but that's...
Yes. Anyway, that's the order he makes on Rahmatullah. And then on the Iraqi civilian litigation, the order is on page 8072, this time paragraph 2.
Sorry, I missed that. Where...
8072.
Yeah.
And the relevant paragraph is para 2 of the order. It's a part of the declaration. So that's Mr. Justice Leggett. And then the Court of Appeal with whose reasoning I'm going to have to grapple because they effectively altered and disagreed with the conclusion and reasoning of Mr. Justice Leggett, who had been in our favour on this issue. The Court of Appeal, you have two versions of the judgment in the core volume, which no doubt irritatingly increases its weight. But you can tear out the pages, I think, that aren't the law report. You have the two weekly law reports version beginning at 7944 in the core volume, which, unless it's inconvenient, is the one I'm going to use. And their reasoning on Crown Act of State, you'll recall from earlier hearings that they dealt with a whole series of issues, but their reasoning on Crown Act of State, i.e. the relevant reasoning for today's purposes, begins at paragraph 299 on MS 8041. And that passage of the judgment runs from 299 to 374. Those are the relevant paragraphs. So 8041 in the electronic up to 8064 in the electronic. And we've summarised the Court of Appeal's reasoning, or the essence of it, in paragraph 36 of our case. And the orders made by the Court of Appeal, one can see most conveniently from page 8065, the final paragraph of their judgment. So they effectively allow the appeal in Serdar, not covered by Crown Act of State as their conclusion, and then they vary so as to introduce their new heightened test, public policy test, which I'll come back to, but they effectively vary the orders of Mr. Justice Leggett that we've just seen, as you see from paragraph 377 on page 8065. So that, I hope, is a helpful introduction of where you find the nature of the preliminary issues, the facts that are relevant to them, and to frame them, and the reasoning of the courts below. Can I move then to the submissions on the substantive issue, which is before the court for today? And the first submission that I make is that both the jurisprudence of the courts and the academic commentary has long recognised two conceptions of a single doctrine of Crown Act of State. The first is as a defence to a tort claim, and the second is as a principle of, quote, non-justiciability. And there are some questions about precisely what that latter concept means, but those have been the two conceptions. And I start with the case law, and indeed some of the academic commentary, just to try and make good that proposition that that's where the case law and the academic commentary now sits. I will have to address later whether that is a place where the law should sit, but that it does sit there is the subject of this first submission. And you won't be surprised to hear that my principal foundation for that in the case law is that recognition of the two conceptions of Crown Act of State is to be found principally in the leading House of Lords authority on this issue, which is Attorney General and Nissan. And you find that authority in Bundle 1, which contains the core authorities, Tab 3, Electronic 9047. Mercifully, and perhaps for once, most of the key authorities are indeed in a single first volume of authorities. Most of the core
We'll check on that statement.
Well,
Day and a half.
we'll check it, keep a rolling check on it at lunchtime. But anyway, at least in preparing it, I did keep coming back to volume 1, which was comforting. Attorney General and Nissan, the classic recognition of those two conceptions of the doctrine that one finds in the speech of Lord Wilberforce at page 9099. And you'll see he starts at the top of page 9099. This necessitates at least some consideration of the doctrine of act of state as it affects British subjects, not to have to deal, if only provisionally, with some arguments of general scope. And then it's the analysis that then follows that. In particular, the two rules, as he describes them, between B and F. And I invite you just to read that passage. So you'll see that he starts with a definition which, as it were, is or appears to be being treated as being common to both of the rules. That is the quotation just by the letter B from Professor Wade. Then introduces the caveat or rider that it's less a definition than a construction from where past cases have gone, and also the caveat that it can be developed as cases come before the courts, but then identifies or splits out the two conceptions which appear to be inherent within the doctrine.
Do any of the five judges agree with any of the others?
My lord, there is a little agreement. There is certainly a 4-1 agreement on the basis on which the non-justiciability limb, which was the only one that was actually before them, there is common ground, at least between the four of them, as to how that should be disposed of. They all said in relation to that, although there are some things that could probably be characterised as Crown Act of States for that purpose, namely the making of treaties or whatever, the way in which the argument had been presented on behalf of the attorney was to say, we're sufficiently close to that, or that decision to commit British troops to Cyprus as part of the peacekeeping pursuant to that treaty with the government of Cyprus. We're sufficiently close to that to fall within the doctrine, said the attorney. And four of them, at least, surrounded the proposition that that was not a well-founded plea, and it was not a well-founded plea essentially on the basis, and therefore didn't fall within the concept of non-justiciability act of state, and didn't do so because the connection was far too tenuous or remote, is the way most of them analysed it. And the essential thrust of the reasoning that they all adopted in that respect was to say, it's one thing to commit forces, it's one thing to conduct military operations. There is, however, nothing, as it were, by way of that can properly be described as a Crown Act of State in deciding you're going to billet them in a hotel, or still less that they're going to damage it when they're there. Bivouacked in the open air might have been just as good.
So any remarks on the defence rather than justiciability aspect are obiter?
My lord, I think that's strictly right, although, of course, as Lord Bingham said on a number of occasions, there's obiter and there's obiter, and they plainly did in this set of judgments seek to consider with some care the broader reach and scope of the doctrine in order to inform the analysis that they ultimately undertook. But I think my lord is technically right.
Yes, but A's obiter and B was their agreement on what the defence was.
On what the defence...
On what the defence aspect was, actually. Yes, what was the law on that?
Well, my lord...
That was Lord Wilson's question.
Yes. I mean, I don't think... They examine more broadly the doctrine of Crown Act of State without seeking, apart from Lord Wilberforce in this passage, to split out the two conceptions of it. You don't find much or anything similar to that split in the other judgments, although there is much that is common in terms of their analysis I will seek to demonstrate. But Lord Reid, for example, we've set out, perhaps in direct answer to my Lord's question, if that's how it's properly to be understood, the extent of what we say is the agreement, at least of with the thrust of that two conceptions approach from Lord Wilberforce. We've set out what the other law lords had to say on that issue in our case at paragraph 41. To take two examples of that, if you go back into the judgment of Lord Reid, who was when I was describing the extent of agreement, the 4-1, he was the one. He did it on the basis that it didn't apply to British subjects. That was the essence of his reasoning. He thought it might potentially have been a Crown Act of State, but nevertheless it couldn't apply to British subjects. So that was the essence of his reasoning, whereas the others did it on the Crown Act of State basis. But if you go back to his judgment, 9075,
Thank you.
between E and F, perhaps E and G, you'll see in those two paragraphs that his treatment of the two cases, and you'll recall from Lord Wilberforce at 9099, the two cases cited for the first rule, i.e. the defence rule, were Burren and Denman and Johnson and Pedlar. And you see a pretty similar looking treatment by Lord Reid of those two cases, including the reference to it being no defence in the third line below the letter E, to plead and so on. That's the Johnson and Pedlar part of it.
Yeah.
And then the Burren and Denman part of it, again, just by the letter G, English courts cannot give redress to that alien, and then penultimate line of that paragraph and into the final line, but he has no legal remedy in England. So his analysis appears to be very similar to the analysis, at least on this defence to tort conception, of those cases which Lord Wilberforce relies upon for the tort defence part of things. So that's Lord Reid. And then Lord Morris, 9084, between D and E, examining the nature of, or the variety of meanings that the phrase Act of State has. Do you see that little passage just above D? It starts, this involves consideration of the phrase Act of State. Yeah. If you read just to the end of that paragraph. And again, there seems to be that distinction, call it jurisdiction or justiciability, if you will, immunity, defence, if you will. But there's a both of the Wilberforce conceptions, if I can put it that way, we respectfully submit are encapsulated between D and E and Lord Morris's speech. And then he analyses rather fully both Burren and Denman and Johnson and Pedlar, the two on which Lords Reid and Wilberforce had relied for this purpose. And that analysis is set out at, I'm not going to invite you to read it all now, yeah, but it's between 9087 at the letter B, where he starts dealing with Burren and Denman, and it runs all the way through to 9089, just below the letter B. Yeah. So those are the passages in which he's analysing those cases, and I respectfully submit that his analysis is broadly similar, at least in terms of the conception of it as a defence to a tortious claim, as Lord Wilberforce and Lord Reid. And just for good measure on this, we've given you some other references in our case, as I said, paragraph 41 to their other lordship speeches. Yeah. But if you go back to Lord Denning in the Court of Appeal, very briefly, if you keep that Nissan judgment open, if you would, but bundle 5, tab 37, which begins at MS 10,606, and the passage we want is at 10,658. Perhaps for good measure, just to show you Mr. Justice John Stevenson's judgment at first instance, 10,640 first. This is the judge at first instance in this end. And you'll see the analysis of Burren and Denman and Johnson and Pedlar between B and C. Do you see there's a sentence between B and C, but in Johnson and Pedlar? Could I invite you just to sideline that down to the end of that little paragraph? Cannot be set up as a defence that the act was done and so on, but there's an exception to that, so treating it as a situation in which you could set up the defence. That's 10,640, and then Lord Denning on 10,658. And again, it might be thought that his second and third categories on page 10,658 are essentially the Wilberforce non-justiciability, the second, and Wilberforce defence to the tort claim, his third. So you'll see the second one is, he refers to making treaties and annexation or conquest, and then by the letter B, act of state not cognizable in the municipal courts. And then at D, when British troops take or destroy the property of a foreigner in territory outside Her Majesty's dominions, the foreigner cannot sue for damages in the English courts, must seek redress through his own government by diplomatic channels. That was established by the celebrated case of Burren and Denman. So it's the same sort of distinction that has fed through then into the speeches in the Lords, and expressly in the judgment of Lord Wilberforce, as we've seen. So I'm going to put away bundle 5. It's perhaps worth noting in relation to Nissan in the House of Lords that, as I've already indicated, the conception of a Crown Act of State as a defence to an action in tort was not run in argument by the attorney on the attorney's behalf in Nissan. But as I've said, there was a broader analysis of the nature, scope and character of Act of State in all its conceptions in order to inform the court's reasoning. And the attorney evidently thought, it appears, that the tort defence could not be run against a British subject. And in Nissan, the person concerned was a British subject. And it couldn't be run as against a British subject because that, it was thought, had been decided, or it was thought at the stage when the attorney was making that forensic decision, no doubt before Mr. Justice John Stevenson, and then following it through in the higher courts thereafter, it was thought that that principle was established, namely that Crown Act of State did not run against a British subject. It was thought that that was established in the cases of Walker and Baird and Johnson and Pedlar, which you see referred to frequently through the judgments in Nissan. And for your note, that was the conception. That was the conception, appears to be confirmed by Mr. Justice John Stevenson's judgment. I don't invite you to turn it up again, but at 10,640, between the letters C and E, he describes the principle in that way. But it was also evidently thought on the attorney's behalf in Nissan that you could run the non-justiciability version or conception of Act of State if you could bring the acting question sufficiently close to something like committing troops or making a treaty. So there's a proximity analysis, appeared to be the thinking, irrespective of whether they were or they weren't a British subject. So as it were, as a way of getting around, the argument was shaped as a way of getting around what was seen to be a hard and fast rule that you couldn't run it against a British subject. So that explains the nature, and some of the academic commentary that you will have seen emphasises, we respectfully submit correctly, that in order to understand Nissan, you do need to understand what the shape of the argument was and why it was done in that way. But it appears to have been shaped, as it were, by a conception of a hard rock in the way of running Crown Act of State against a British subject, and therefore trying to bring it within a doctrine which was believed to apply irrespective of the citizenship of the person concerned, of the claimant. But, and it's quite a big but, as we have seen, there was in the House of Lords in Nissan quite a big debate between their lordships as to whether or not that rock truly was a rock. In other words, whether or not Crown Act of State could in fact be run, even as against a British subject. That was the basis, i.e. that Johnson and Pedler and Walker and Baird and that line of authority did indeed establish that proposition, that you couldn't run it against a British subject. That was a conception of the principle that was accepted and applied dispositively. That's why he was the one of the five, by Lord Reid. If you still have Nissan House of Lords open, you see that on page 9075 at the letter E, first sentence. And he returns to it, having considered the authorities with that principle in mind. So he's looking at the authorities with that principle in mind. He returns to his conclusion on that front at 9081 between C and D. And that is the basis on which Lord Reid disposed of the appeal. Others, however, were dubitante on the point, and one at least, Lord Wilberforce, saw very considerable force in the opposite view. One sees that in the height of the case against. The others effectively declined to determine the issue because they saw it as a point of considerable complexity and were able, they thought, to take the attorney's argument at face value, assume that it was correct in principle and reject it on remoteness grounds. But you see from 9081 what Lord Reid's conclusion was, and Lord Wilberforce at 9103 between D and E.
Your position, as I understand it, is that we should clear off the question whether it applies to British subjects or not. Is that right?
Yes.
Now, I can see that so far as we are trying to ascertain what the law presently is, that might be the sensible course. But if we are asking ourselves what the law ought to be, then it might be thought an objection to your submission that it contains a distinction between British and foreign interests, which may not be easy to justify rationally. So that in that part of your submission, we may actually have to address this question, may we not?
My Lord, I maintain the position that it's not necessary finally to determine that issue. You won't perhaps be surprised to hear me say that if push came to shove on the point of principle, I would prefer to line up behind Lord Wilberforce on this issue. But
it enlarges the scope of your client's rights.
It enlarges them, but it might also be thought to have an inherent logical force.
It has to be this, yes, what you're saying, but that applies the other way as well. We're geese and ganders to some extent.
My Lord, it does. So the point can be played both ways.
I suppose Lord Wilberforce is a good man on have on your side, then so is Lord Reid. So.
They're both marvellous people to have on one side. So one is on double alert if they're disagreeing with each other. But the reason that I say, other than the wholly altruistic reason of expanding the Crown's rights, it might be thought that Lord Wilberforce is to be preferred in that respect.
Lord Reid put it very strongly. He said it'd been the law for centuries.
Lord Wilberforce said.
No, Lord Reid.
Lord Reid did, but the others disagreed with it. It had been clear law for centuries, as you will have seen from the judgments. But the attraction of Lord Wilberforce's analysis, it might be thought, is that if the conception of Crown Act of State works, and its rationale is as I'm going to submit it is, I'll develop those until I get to them, as it were, but if the rationale is effectively as I submit it is, then it makes more sense for it to apply to all of those who might bring claims, irrespective of of citizenship. And we do also acknowledge the potential real difficulty, it may be that one could justify it, but the potential real difficulty that would be thrown up under Article 14, amongst other things, of the ECHR, if one were to have a principle which distinguished in that.
The only contrary argument of principle, as far as I'm aware, is the argument that because the British Crown owes obligations of protection to British subjects, if there is a British-owned factory in Dresden in 1945, the position is quite different. That might be thought that in situations of armed conflict, the obligation of protection of the British Crown was a tad irrelevant.
And might be thought, for that reason amongst others, not to go far enough for the purpose of justifying that distinction in the context of this principle. And I think there is another, in fairness to the arguments against that, there is another idea, perhaps more fundamental idea, lying behind it, or a linked idea lying behind it, which you'll find in the judgment of Lord Justice Elias in the Court of Appeal in Al-Jeddah No. 2, which is there is a difference because there is a relationship, a prior relationship of protection and other things between the British subject and the Crown. But again, my answer would be the same, which is it might be thought that isn't so interesting, still less is it sufficient for the purpose of this principle.
Clearly applies in relation to children on the basis of allegiance. So why would it not also apply in relation to adults on the basis of allegiance, leaving aside the wartime situation, which may, of course, raise countervailing considerations?
Well, my lady, I suppose the choice ultimately is whether or not it may be slightly premature to have this debate because
All right.
well, I suspect, no, the only reason I put it that way is not to duck the question, but just to say that the point I've already made, which is that to some extent, whether or not British subject or no British subject should work in the context of this doctrine slightly depends on how you conceive the doctrine to be and what you conceive its rationales to be. And if those rationales are entirely, as it were, unrelated to the distinction between one subject and another, then it doesn't look terribly attractive to draw that distinction, to impose that distinction on top of it.
If the content of the rule is limited to acts of force outside the territorial jurisdiction of the UK, that's a context in which it's much less easy to justify a difference between British and non-British lives or property.
My Lord, I totally agree with that, and subject only to the caveat, and I know that was a thought that Mr. Justice Leggett had in one of his two judgments. I think it was initially in the Serdar judgment he had that thought, is it limited in that way? Just a little care perhaps with the way in which that is formulated, simply a doctrine in relation to the use of force, because we respectfully submit that if it works in relation to the use of, say, lethal force, it should equally work in relation to other acts the state participates in as part of military operations abroad.
I mean, are there any sovereign acts, which I think is the category that you would confine it to, other than the use of force, which might give rise to the defence for which you contend based on act of state?
Detention.
Well, that's an act of force, isn't it?
Well, my Lord, if you categorise it in that way, yes.
An act of, not necessarily destruction, but an act of physical force.
Yeah, acts which are necessary for the part of the conduct of military operations. And as I say, I mean, the broader question that you ask me is, can I conceive of other situations outside that? What I don't want to do is to completely close the door. We see that Lord Wilberforce had said the thing can develop, the doctrine can develop as cases come in, and there may be other situations in the future, but for present purposes, the issue arises directly in the context of military operations abroad, armed conflicts abroad, and the steps that are necessary for the purpose of pursuing those. So that is sufficient for my purpose, and that is really the confine of the argument of principle that happens before you today.
Can I ask, are we simply talking about the non-justiciability leg of the two legs which you have referred to, or shown that Lord Wilberforce referred to, at the moment? Have we been discussing both legs? Or?
My Lord, we're discussing both legs, but we're only doing it for the... I'm going to try and build the argument, but for the purpose of this, all I'm trying to show you is that in the case law, there is this dual conception. Now, what it means and how far it extends and where it goes and what its rationale are, I'm going to come to. But at the moment, I'm simply on the proposition, what does the case law demonstrate about the court's understanding?
Yeah, we were talking about whether British citizens could be affected by the principle. Does all of what you've just been saying apply to both limbs?
Well, yes, it does, is the short answer to that. And yes, it does, because the submission I'm ultimately going to make, I don't be coy about it, the submission I'm ultimately going to be making is that it exists as a defence to the tortious claim, or it can be analysed, or it can be analysed as a non-justiciability principle, as long as one understands what the non-justiciability principle includes.
As long as it comes up down to the same thing in the end.
Well, it does in the end come down to the same thing. We respectfully submit that non-justiciability, I'm going to be submitting, that non-justiciability includes those things which are inherently unsuitable on account of their subject matter, to draw a well-known phrase from Shergill. So it includes those things, but it isn't limited to those. And in this context, that limb can and should be perceived as in effect being a rule of jurisdictional restraint by the courts. Yeah. And if you conceive the non-justiciability limb in that way, there is virtually nothing in terms of principle that turns on whether you view it as a no jurisdiction or whether you view it as a no defence, because the same question of principle...
As a defence?
Yeah, as a defence. The same questions of principle will have to arise, namely, because both engage the court's decision-making about what the requisite substantive elements are before either consequence happens.
If they're non-justiciable for one type of defendant, for a claimant, they're non-justiciable for another.
Exactly so, but I mean, you'll see when the argument develops that we don't, as it were, hang our hat on non-justiciability in its ordinary meaning. No. We accept that if it's just a question of is this sort of thing the detention under foreign law, is that the sort of thing that is inherent?
It's an issue the court shouldn't be determining. It's sort of self-denying.
Exactly so. But if you view it in that way, then you have the same driver that applies to the doctrine. You don't get, as it were, hung up on the bedeviling linguistic distinctions, but you do end up asking common principled questions about what conditions the court should set, what criteria there should be before the court will say, we are not going to do it in that way. We are going to give you a defence, we're going to accord a defence a matter of common law, we're going to treat it as it were, a self-denying jurisdictional thing.
It's a question of label, right?
It's a question of labels, and that I think is one of the underlying themes that comes out of Nissan.
Well, it's the question of labels if non-justiciability is limited and has been meant to be limited throughout to what you can perhaps label no tools. Courts can't do it.
Yes, exactly.
The butt is gas, if you like.
But you will have seen from our case...
Oh, I understand what you're saying. But I mean, if against you it is said, as I understand it, that is what non-justiciability means and is limited to, that takes you down a different route.
Yes, that's exactly the case against. But that case, as you will have seen from our case, I wasn't just going to recite the argument against it, but as you will have seen from the way that we formulate the argument in our case, if that is the right conception of it, then we accept that there is no further resistance from us, if that makes sense.
Exactly so.
So our argument depends upon there being either a species of conception of the Crown Act of State which is tortious defence, or construing non-justiciability in the jurisdictional sense I've just described, both of which then lead to the same set of questions.
I mean, the form of non-justiciability you're actually relying on is not based on inherent unsuitability for judicial decision, but on the constitutional separation of powers.
Exactly so.
That may not be, I mean, that may be the origin of it without necessarily defining its ambit, but it's why, if we have such a rule, we have it.
Exactly so. Exactly so. And the difficulty, which is perhaps is something which has flowed through the now too often cited to be gone back to paragraphs 41 to 43 in Shergill. But it's that sort of issue that I rather suspect the court may have had in mind when formulating those paragraphs. You put it on the basis of separation of powers, which we agree with, but the key thing is there a distinction, as it were, between non-justiciability strictu sensu, it might be thought, namely inherent unsuitability on the one hand, and on the other hand, a whole raft of different rationale which might underpin a whole raft of different rules. I think the way it was put in para 41 of Shergill was to say, if you look at act of state, you weren't distinguishing between crown and foreign, but if you look at act of state, that is, as it were, a separate species of rule which creates, in effect, and you can describe it in this way as well if you want, an immunity. But it doesn't terribly matter whether you call it a jurisdictional restraint, or you can call it the court conferring an immunity, or you call it a defence to a tortious claim. All of that is labelling. The question is, what are the principles, are there principles, and if so, what are they, that should lead the court, however described, to that self-restraining conclusion? That's ultimately the way I'm going to sit down now, that's almost the way the argument is going to be framed. But I was still on Nissan at the early stages of the argument, and the purpose of labouring Nissan was at least to make the point that at this stage, the House of Lords, although they are only directly concerned with the non-justiciability argument, because that's the only argument that was being run on behalf of the attorney, do consider the nature of the concept more generally, and do all of them involve, certainly the three I've taken you to, and I think the others too, do all draw that distinction between non-justiciability strictu sensu and defence in tort, if that's the way you want to look at it. And as I say, they didn't need to get into that issue because the four of them, who didn't reject it on the basis that it involved a British subject, did so on the basis of taking the attorney's argument at face value and rejecting it on the facts, simply too remote or too tenuous from what they regarded as being the paradigm non-justiciable strictu sensu things, namely the making of a treaty, the committing of troops, and so on. But it is perhaps of some interest in working through that analysis to see how they ultimately disposed of it. If you go to Lord Morris, first of all, just to show you the ratio, effectively, of the four. If you go to Lord Morris at 9084G.
Which page?
9084.
Ah, 9084G.
Sorry,
yep,
9084 by the letter G.
Yes, no, I've got it, thank you.
It's only a very short passage, but it's that paragraph that spans that page and the next page.
Which is effectively, if I've understood it, probably not, this is just procurement.
This is just procurement. They could be bivouacked in the open.
Yeah.
It's got the connection is far too...
So what is the ratio of this decision then?
The ratio of this decision, the strict and narrow ratio of this decision, of the four, is that
But what is the proposition of law which would make this binding on, say, our court?
Well, I'm not sure if you're looking at it in terms of ratio. You get much more than that the act of...
Don't know is the answer, isn't it, or what?
Well, no, the act of placing troops in a hotel in this way does not fall within the concept of act of state.
Whatever it is.
Whatever it is.
Fall within the concept of non-justiciability.
Nor within the concept of non-justiciability as they define it, yeah. But I think that's back to the point that my Lord the President was putting to me earlier, which is that the whole thing for almost every purpose is obiter outside that, and I understand that, but it is nevertheless a useful and helpful examination of the nature of the doctrine before they get to that short way of disposing of the thing on the facts. But that's Lord Morris, that's how he does it. It might be thought that the true ratio of his judgment is in the sentence just above C on page 9085. There's an air of unreality in talking about acts of state in relation to the arrangements for the housing or provisioning of troops, my Lord.
Yeah, but if you need the building to put your machine gun nests in, it might be different, I suppose.
It might. It might, and it particularly might be different, as one sees from Lord Pearson, which I'll come to just in 1 second. But Lord Pearce, if I may, next. 9095 between B and C.
Yes.
Next door to which, coincidentally, in the light of Lord Clark's question, I've written ratio.
9095 B to C is the ratio.
9095 B.
Opposed to the paragraph between D and E.
Yeah.
Yeah.
Lord Wilberforce summarises the argument at 9098 at H. That's perhaps the clearest conception of the argument.
Yeah, then we go straight into the 2 points.
Yeah, that the argument was running. That's the argument that was being run. And he rejects that as far too tenuous a connection. That phraseology one finds at 9103. at H. Between these acts and the pleaded agreement with the government of Cyprus, the link is altogether too tenuous. Indeed, it's not even sketched out, and so on.
Why they took it.
And then Lord Pearson, who is of some interest here, because, as you'll see, the reasoning of the rest of their lordships is, and indeed of Lord Pearson when we come to it, his relevant bit is at 9107, the paragraph beginning just above G, over to 9108, at the end of the first full paragraph on the next page. But he does the same thing, which is effectively to say it's far too remote and tenuous a connection. But the interest, perhaps it might be thought, of that little passage is that he's the only one who, as it were, strays beyond pure treaty making and the committing of troops and delves more generally into the question whether there would be acts of state in the conduct of military operations. So if the provisioning of putting them in the hotel was too tenuous and the treaty making was squarely within, there is a spectrum between, and he explores rather more fully than some of the others do what might fall within. Of course,
yes, at B on 9108, the test he seems to approve is urgent military necessity.
My lord, exactly so, which is, I think, Lord Hughes's nest of machine guns
yes.
property, but is my more rather grist to my rather more general mill, which says if you're looking for in these judgments for a flavour of what would have been conceived of act of state, putting the troops in the hotel won't do it, but other things that are part of the military necessity.
Urgent military.
Military.
Urgent military necessity, to use the words of Lord Pearson.
Yes, he's simply giving an example.
Yes, I'm
rather
not
than
saying
seeking
that.
to
He's not
define the universe.
A sort of statutory definition, but it's interesting he uses the word urgent. Fighting or urgent military necessity. Those two.
Yeah.
Yeah. Fighting or. Anyway, urgent.
Yeah. Anyway, that's the first proposition. Two conceptions of it in Nissan.
At least.
And you will have seen that the principal authority cited for the tort defence aspect of it, again, I'm going to stick to that conception for the moment, if only to try and address the it's only a non-justiciability strictu sensu principle argument, and without prejudice to my point that it doesn't terribly matter outside that bubble how you characterise or describe it. But you will have seen that the authority principally relied upon is Burren and Denman for the tort defence aspect of it. And this is the Burn the Barracoons case, which has led to some entertaining research, including someone diligent has found and put into your bundle number 9, I don't know what tab, but it's somewhere in the small bundle 9, a transcript of Captain Denman's evidence at trial, which is, someone did try and persuade me that there was a legal reason for going to it. I'm not sure I'm totally persuaded by there being a legal reason for going to it, but it's quite entertaining reading if you had a moment or two. It's also perhaps to be noted that Captain Denman was the son or nephew of the Lord Chief Justice.
As Lord Denning tells us.
As Lord Denning tells us, which I'm sure had no impact on the result whatever. But Baron and Denman is at Bundle 1, Tab 1. I think that's a point against myself. But Baron and Denman is at Tab 1, and the submission is going to be that Nissan and Lord Wilberforce, if I can say this with great respect, correctly recognise that Baron and Denman stands as authority for the proposition that there is a separate conception of Crown Act of State outside the inherent unsuitability, non-justiciability.
Is there anything before Baron and Denman to support that, or does it start with Baron and Denman?
I think the earliest we've got is Baron and Denman.
A bit odd that this whole thing rests on, or bit from Baron Park, a direction to a jury, and the whole edifice is based on that.
Well,
I know there were 4 other judges with him, but
yes, to some extent the whole edifice is based on that, but they do then come back to it, as I will show in a moment, in a variety of later House of Lords and Privy Council decisions, and consider the principle, consider its correctness, and uphold it effectively.
I made a little note on 9016, the Attorney General's argument.
yes.
Right down at the bottom, the argument was, if the Crown makes a treaty, no subject has a right to bring an action or anything done in pursuance of that treaty, whether sanctioned by the municipal law or not, his assent is virtually implied to every act of his own government. And then there's a case cited, and I made a little note to find out whether you'd looked at Conway and Gray, and if not, to get my judicial assistant to do so.
Well, my lord, I confess, I'm afraid, a lack of diligence in that respect. I haven't got Conway and...
We'll do that.
Well, we can easily...
I mean, part of the problem, surely, is that it was pretty clear that Captain Denman had exceeded
Yes.
the whatever power was conferred on him by the treaty, and
Yes.
that was why that was why it was necessary
Yes.
to deal with Crown Act of State on a wider basis.
Yes. I mean, that, my lord, we respectfully entirely agree. I mean, I'm sure the court will have had a chance to have a look at Baron and Denman, so I'm not going to laboriously go through it. But one of the big points on it is that there is some attempt in the Respondents' case to suggest that the acts in issue in Baron and Denman were carried out pursuant to the treaty, with a view, no doubt, to saying that this is therefore to be analysed as a non-justiciability.
They weren't.
But it's just simply wrong. He wasn't acting to enforce or implement the treaty. Indeed, he was evidently acting beyond it.
That's why he needed ratification.
That's why he needed ratification, but one sees it very, very clearly in terms of the incorrectness of that analysis of it. If you go to 9015 and you look at the letter from the then Foreign Secretary, Lord Aberdeen, you get a pretty strong flavour from the first 10 or so lines of that letter at the bottom of 9015 that he was acting outside any permission, implicit or otherwise, given by a treaty.
Yeah.
You see that from the sole defence run by the attorney. My Lord Wilson has drawn attention to that passage just above the last paragraph on 9016. But you'll see the defence that was actually run in the final sentence of the next paragraph over on 9017. The effect of this ratification by the Crown was to render the defendant's act an act of state in respect of which no cause of action can be maintained. So they were forced into that position precisely because the earlier principle didn't apply in relation to the treaties.
And you say that I think if you look at the interesting article by the late Amanda Perot-Saucine, you will see that she suggests that there are two prior decisions which set the stage for the Crown Act of State. One was the Nabob of Arcot against the East India Company in 1793, And the other was the one you've just referred to at the foot of the argument of the Attorney General, Elphiston and Beedred Chund, although both of them are extremely briefly reasoned in their final analysis.
Yeah. Well, I'm sure we can get hold of those as well if we need. Just to finish on this point on the treaty, if you go finally to 9012, you see there's the third full paragraph on the page. The following facts were proved in evidence. 9012.
Yep.
About a third of the way down, the following facts were proved in evidence. So it then sets out a series of facts. That's the lead-in. Lord Aberdeen's letter forms part of that. And I'm still on whether he was acting pursuant to a treaty, but you see from the facts there summarised. You just cast a brief eye down that paragraph in the middle of that page 9012, just before the quote. So you'll see that lots of the things about which complaint was made happened before any form of treaty with the local king had even occurred. So on the 19th of November 1840, Commander Denman went into the Galenas River, captured the 90 slaves, took possession of the barracoons, spiked the guns, placed sentinels at the door, and secured the release of Fry Norman and her child. It was only on the 21st of November that the treaty was entered into with the king, and it's to be noted, pursuant to that treaty, no authority was conferred on Commander Denman to go around burning the barracoons. That was an obligation that, as it were, by treaty was assumed by the king himself. But nevertheless, he proceeded to do so and to liberate the 841 slaves.
Elphinstone seems to
And it was for that reason that
during wartime they surrendered. The war was still going on.
It was for that reason that the defence was run as it was, of ratification.
You've made the point about it's the job of the king to destroy the factories, but then it goes, after the treaty is set out, it says that 2 days after the treaty, namely the 23rd, the defendant, in execution of this treaty, commenced burning.
Yes, although quite how that doesn't look as though it's borne out by the terms of the treaty, unless there was some intermediate step of
Possibly
permission.
that's what he thought he was doing.
This is a statement by whom, the statement of facts? Is it the law reporter or what?
I think it's the law reporter. This isn't in any judgment. The only judgment, or summing up, starts at page 9017. In the summing up of Part B. Do you see that in the final paragraph on that page?
And there were 4 judges, were there?
There were. If you go back to the first page of the judgment, Barons Alderson, Rolfe and Platt. And you see, if you come to the summing up, just to show you the relevant bits of that, the key part, perhaps, is the part on page 9018, beginning with the principal question is, in the first full paragraph on 9018. And you'll see that, perhaps just a note before you get there, that the paragraph that precedes that in the summing up effectively says that this was a tort under local law.
Where do we find that?
In the opening part of the summing up, starting on 9017. Dealing specifically with possession of the slaves, but he's making the point there that there was nothing in the local law to preclude slavery, the keeping of slaves, so you could perfectly happily possess a human being under the law of...
And it wasn't an international crime.
And
like
it wasn't an
piracy.
international crime. There'd been that argument in an earlier case, but it wasn't an international crime.
The point on the treaty is around the bold paragraph number 188, or page number 188, isn't it?
Yes.
If the defendant had merely instructions according to the terms of the treaty, they would only have extended to stopping ships in the High Seas.
Yes, although one needs to be a little careful about what...
That's the treaty with Spain.
Yes, exactly so. There are two treaties floating around. One of them is the Spanish treaty, but that only permitted stopping on the high seas, not burning barracoons and taking the slaves.
Yeah.
The second of them is the treaty that was subsequently entered into with the local king, whose terms are just a little doubtful, given that Captain Denman did himself then do the burning. But it is at least of some interest to note that the things that, as it were, force one to the point of this tort defence depending upon the ratification or prior authorisation of the actual act by the Crown.
I see that there was ultimately a settlement before
Yep, it was.
well, the Bill of Exceptions could be.
Exactly so.
But this was only an address to the jury, so you mightn't find, a very fine jurisprudential analysis. Nevertheless, I mean, standing back, Mr. Eady, what have we got? We've got ratification equals authorization. Authorization equals act of state.
Yes.
And that's about it, isn't it?
That is about it, but it evidently, the reason I think it's then cited by Lord Wilberforce as the first of his two conceptions is because, as we see from the introductory paragraph in the summing up, there was no inherent unsuitability of determining whether or not what was done was unlawful as a matter of domestic law. And so act of state as a tortious defence or as something outside the inherent unsuitability doctrine is a necessary consequence of this summing up. And that is how it is taken in the later cases. But in my respectful submission, that does flow in particular from an acknowledgement that there was the local law, they knew what it was. It said you can possess slaves. There was nothing difficult about finding out what the local law was, it appears, or acknowledging that you could possess slaves and deal with them under local law. So the defence had to be a defence that had nothing to do with the inherent unsuitability of the exercise. It wasn't a judicial competence thing. It was a judicial decision that in relation to certain types of act, sovereign act committed abroad, these courts shouldn't lend themselves to a tortious cause of action.
An argument that the Attorney General doesn't seem to have run.
Well, I'd rather take in that argument as being...
Therefore wasn't met by counsel for the defendant, for the other side.
I might think it's not a terribly sound basis for a decision of what the law is in our days today.
Well, if it stood alone, they would be forced to that. But it doesn't stand alone. It stands having been analysed by repeated House of Lords over the years, including by Lord Wilberforce in Nassau in 1970. So although its genesis and origin may be light.
In 1970, in a case which didn't actually base its decision on Buren and Denman.
Would we not find it more helpful to look at cases where the defence has been fully pleaded and accepted?
Well, this
I'm
is
not sure there are many of those.
There aren't many. There aren't
any of them.
Well, there was the Comanche
has been,
case.
I
The
mean,
Comanche case, I suppose.
It's been laid down fairly categorically by a number of people, albeit in slightly different terms, that such a principle exists. At the end of the day, we have to stand back, I suppose.
So should it?
But some of them put it in terms of unjusticiability, don't they?
Some of them do.
All I'm getting at is that it's always very helpful to look at circumstances in which a doctrine has been applied in clear terms to a set of facts than it is to look at cases in which a doctrine has been stated in contexts where it has not applied.
Well, my lady, I'm sure that's right as a point of general principle, but you will be aware from the cases, I'm sure having read them, that there aren't that many, if any, in which it has been applied in that way. What has happened instead is that lots of the case law has turned on the question whether it applies or doesn't apply to those who are on British territory, to whether or not it applies to those who are or are not British subjects, And in relation to those cases where it has been applied, I fully acknowledge, including cases like Camachi, the one my Lord Mance referred to, one can, as it were, see the non-justiciability strictu sensu principle much more closely to the fore. So, I mean, I entirely take the force of my lady's point as a point of general approach, but it has nevertheless, in those cases, perhaps I better come to them, it has nevertheless, in those cases, been accepted for the principle that Lord Wilberforce took it for. And in my submission on its facts, you may say, well, it's light and it's old and it's strange and there are a variety of reasons in which one can get round it, as it were, but it is of some interest that it starts with a proposition. There's no difficulty with going to the local law, finding out what that is, determining. It isn't a non-justiciability point, he wasn't acting pursuant to a treaty, and so the remaining line of defence, and its only explanation is, this is a defence to the tort claim.
Well, you'll have some point to try and put a cigarette paper between the factors which condition a tort defence and an unjusticiability defence, because reading your case, it seems to me that I think, as you said earlier this morning, they are very, very similar, if not identical, considerations.
They are. Once one strips out the inherent unsuitability aspect, once you're outside that bubble, I suspect, there may be virtually...
What's curious about Baron Park's reasoning is that he says it would be fine if it was under the treaty, but it wasn't under the treaty. Therefore, we have to look to ratification. But he doesn't stop to say, well, of course, ratification by the state isn't the same thing as action under a treaty. There's just the implicit assumption that it is. And then he goes into great detail about ratification.
My Lord, he does.
He doesn't really explain why ratification by the state is, or approval by the state, whether ratification in career or
prior authorisation,
is the same as under a treaty. He just seems to assume it is.
My Lord, again, I entirely accept that's fair. There is no principled exposition as to why it should be. It's just simply treated as being a sovereign act of that kind.
Yeah.
Well, surely the point that was being made was not that ratification made it equivalent to being done under the treaty, but that ratification made it equivalent to being done by the Crown. And the fact of it being done by the Crown was enough to remove it from, or either to make it a defence or to remove it from the scope of judicial action. That is actually the whole point of the Attorney General's second argument.
My Lord, it is. I was going to come back to that. If you go back to 9017, in answer to an earlier question, the Attorney didn't even run this argument. The final sentence to which I think I directed you...
Yeah, that does run it, I think.
...of his argument is that.
Yes. I mean, it seems to have been assumed that once you showed that this was an act of policy by the British state, which you did by ratification, that was the end of the matter.
Yes, that was the argument that's run in the final sentence on the first, not full, but first paragraph on page 9017.
It doesn't seem to have been challenged by Mr. Hill, who seemed to have taken a large number of rather technical points about whether there had been a ratification at all, and whether it had been gazetted by the Queen of Spain and such like things.
Yes.
But he doesn't seem to have
put that in issue.
Argued that an act of the Crown itself would not be an act of state.
My Lord, no. But if one traces that attorney argument reflected there on 9017 into the summing up, there is, of course, a lot on ratification and the meaning of ratification in that to reflect the argument, but the closest reflection in the summing up to the nature of that argument is run by the attorney, you perhaps see on 9019.
And what does Elphinstone and whatever the other...
Elphinstone simply seems to say that the fact that somebody is surrendered during wartime doesn't mean that the state can't rely on the fact there's a state of war until the peace is declared.
That's right, that doesn't seem to be quite the proposition it's cited for.
Well, I think it is. I mean, if just looking at Mrs. Perez-Sosin's article, she says that the issue of seizure was decided on the basis that the the municipal court had no jurisdiction to judge upon the subject in the light of the continuing hostilities. If anything was done amiss, recourse could only be had to the government for redress. There's a splendid irony about that, which that was Lord Tenterden rejecting the unsuccessful argument of Denman KC. Later, Lord Chief Justice, who I see actually was the father.
The father.
Was the father.
Trying to work out whether it was son or not.
Yes.
Father. Sorry, I was going to give you, I hope you had that reference in 9019. It's at the end of the first full paragraph, 4 lines up from the bottom of that first full paragraph on 9019, where if this act by adoption becomes the act of the Crown, the seizure of the slaves and the goods is a seizure by the Crown.
Sorry, 190.
Sorry, 9019.
I'm sorry, 90.
Yeah.
901.
It's the pre-penultimate
Yeah.
paragraph.
Yeah.
Well, as I said, I would, I mean, for good or ill, and flaky or not, as it were, the principle in Burren and Denman has been treated as sound. I don't want to take up a lot of time on it, but...
Can we take it through your written case, or is that be efficient or not?
So can I just give you a couple of references to
course.
Nissan? I'm not going to go back to Nissan for this purpose,
Sorry,
but
yes.
in Nissan, where it treats Burren and Denman as sound, that's the...
Oh, I beg your pardon, yes, yes.
Yeah, so it's Lord Reed at 9075 F to G.
Was it in issue whether it was sound or not?
Well, it's difficult to know precisely how far the scope of the argument went in Nissan. Sorry. I'm not sure anyone directly attacked Burren and Denman, but that's explained perhaps by the shape of the argument.
Fair enough.
So we're back into Overture territory.
Quite right.
But
Sorry, I interrupted.
Lord Reed 9075 F to G, and then at 9076 at C, might perhaps be worth looking at that, in tab 3 of the bundle that you're in.
Which was the first reference is just a description of Buren.
That's a description of Burren
it's
and
been
Denman,
accepted.
but without dissent, as it were.
But it's saying it's accepted, yes.
Yeah, and it may save me going to another case if I show you 9076
Thank you.
at C.
Yes, Johnson and Pedder. Yes.
So that's Johnson and Pedder. Save me having to go to that perhaps, but you'll see the nature of the argument there. That was the alien within the United Kingdom and so on. But you see the analysis between C and G. And in particular, the way
Well,
that...
that's what it doesn't apply to the British subjects point.
It is, but you'll see the flip side of it, which is that at the same time as saying that, they're acknowledging that if you do it to a foreigner, the principle is the Burren and Denman principle. Look at the quote in Lord Finley's judgment, just above the letter F on that page. If an action be brought in the British courts, in such a case it's open to the defendant to plead that the act was done by the orders of the British government, or that after it had been committed it was adopted by the British government. In any such case, the act is regarded as an act of state which a municipal court cannot take cognizance. Foreigner is sustained.
Obiter, yeah, but plain, you are quite right.
Plain, and
there's
citing Burren and Denman,
Yes,
as you see from these.
There's an equivalently plain statement in Butte's Gas. Buren and Denman is stated to be the classic authority for proposition, but the trouble is that we don't have the depth of analysis that we need to resolve the present case.
My Lord, yes, that's true. And the Butte's reference for your note, if you want it, bundle 2, tab 16, Lord Wilberforce at page 9672G.
9672.
9672 at G. Still in this bundle, one of the cases in which the East India Company, in inverted commas, annexed property of a Raja, or unfortunate Raja. Tab 2 in the same bundle is Kamachi, or Sahaba. 9020 is the first page on the electronic.
Sorry, you gave the page number. I was just looking at what Lord Wilberforce said.
Yeah,
Sorry.
and it's tab 2 in the same bundle, it's 9020.
Thank you so much. Oh, yes.
And this is a case in which I think my Lord has read it, I know from the exchanges we've already had, in which most of it's on non-justiciability. We're annexing the territory. It's a classic sovereign act of that kind. How could the courts make a judgment? It's inherently unsuitable. The East India Company can go and take property. And might be doubtful that question, but there plainly was that element to it. But there was also the Burren element, and one sees that from 9043. And the relevant bit, if you look halfway down the page, there's a paragraph beginning, the result in their lordship's opinion, just above that. Will you read the sentence above that?
Right.
If there had been any doubt upon the original intention of the government, it was clearly ratified and adopted. It has clearly ratified and adopted the acts of its agent, which according to the principle of the decision in Burren and Denman is equivalent to a previous authority.
Yeah.
The result is.
Well, that's based on
State interstate.
judicial incompetence, isn't it? See the next paragraph.
Yeah. My Lord, the thrust of it is, but you've got, again, I'm not citing it for the proposition that Burren and Denman was directly dispositive in this case, but it's another case in which Burren and Denman is cited, as it were, without demur, albeit here for the limited proposition.
In relation simply to the ratification principle.
In relation to ratification, exactly so.
Yes, fair enough, thank you.
But the reason presumably one can't form a view is that this is not a municipal law matter, is it? It's not that it's not one on which in another context one might form a view.
Yes.
It really, if one looks at the head note, it's the first 4 lines of the head note which really show what this case is about. And you're quite right, this case is not about this sort of point, but you're quite right that Burren and Denman is treated as a clear authority.
And for no more than that. I mean, the key reasoning is on 9040, if you wanted. I'm not going to take up time with it, because
we looked at it in connection with a foreign act of state.
9040 where?
9040, it's really the first full paragraph.
Yep.
And then in particular, that paragraph beginning, the next question is, what is the real character of the act done in this case?
Yep. We looked at this.
Yeah.
I mean, what they meant by under colour of legal title was that if the East India Company, as delegate of the Crown, had assumed the responsibility of trustee or had acted in breach of some private law obligation, the result would have been different. But because they were operating on the international plane,
exactly so.
That didn't arise.
Exactly so. And that same idea one sees running through Nissan itself. There was no dispute in Nissan but that if the claim had been properly based in contract or pleaded in contract,
Right.
because you would then be dealing with commercial acts and
Right.
under colour of local law in that way. You voluntarily submitted yourself to it. It isn't jure imperi in a nutshell.
Because Mr. Justice Leggett seems to have been understood this as meaning that it was perfectly fine if the Crown acted illegally.
No.
And that's, on the face of it, not what he was saying.
Yeah, we respectfully agree with that. I mean, we don't dispute from the proposition that if the principle was, it made all the difference if the Crown deliberately decided to flout the law, as opposed to pretending to act under it. That would make all the difference. We could see that would be a pretty unprincipled and unattractive position, which I do not espouse. But we agree respectfully with my Lord's assumption that isn't quite what is being said here. This is really drawing that distinction between subjecting yourself to local law as trustee or as part of a commercial transaction or contract on the one hand, and on the other hand, the sort of sovereign act which we're concerned with here, and they were concerned with there. So they are treating in those cases, I should just show you the Al Jeddah 2 litigation, if only briefly, in the same bundle behind tab 4, starting at 9112, with Mr. Justice Underhill as he then was, in Al Jeddah 2. And the relevant paragraph for this purpose again, perhaps doing not much more than citing and relying on Lord Wilberforce is 74, para 74 9138. So he cites and applies Lord Wilberforce's twin conception. And then he effectively, if I can summarise it, I hope I'm not doing him injustice, but if I can summarise the approach in this case, he then treats the non-justiciability principle as being a closeness of connection to what undoubtedly would be a Crown Act of State, the treaty making or the committing of the troops. He adopts very much faithfully the Nissan approach and treats this as being non-justiciability, but you'll see he's identified the twin conceptions of it. And then the Court of Appeal considered this issue, at least two members did, and without going to it extensively now, just to give you the references, the Court of Appeal's judgment in this case is in the next tab, tab 5, beginning at 9152, and the relevant paragraphs for this purpose are in the judgment of Lady Justice Arden, 94 and 106 to 7, and Lord Justice Elias, 195 and 211. So we respectfully submit that those authorities, perhaps more or less directly or indirectly, are all citing Burren and Denman. No one demurs. It's often explained on the basis that it's an exception to your ability to claim in tort, relying on the local municipal law. See Johnson and Pedler in that explanation in that case. But there's obviously, and I fully accept, a muddling up, as it were, in some of these cases, between the one aspect, the one conception, and the other. But no one has cast any doubt on that conception of Crown Act of State as extending beyond the inherent unsuitability for judicial determination category. That's the key point I want to emphasise. And we respectfully submit that that conception of Act of State, including Crown Act of State, is entirely consistent with the way in which the general analysis, albeit in a very different context, but the general analysis that the court conducted in Shergill operates. In particular, recognising Act of State as a species, and perhaps it might be even more accurate to characterise it as this, as a species of immunity from liability. But immunity from liability and a defence of the tort claim are remarkably similar concepts, neither of which depend upon demonstrating inherent unsuitability for judicial determination. And the commentary, the academic commentary, is to similar effect, unsurprisingly and accurately, it might be thought. We've set those out in our case. Just to show you the place. Our case at paragraph 48, and this is on the point that there are twin conceptions, and that it extends beyond inherent unsuitability for determination. Our case at paragraph 48, and that's electronic 12191. We've set out 12199. Yeah, in paragraph 48 we set out a collection of the academic writings on this issue. Perhaps just worth showing you only two. The first, Lord McNair, not because the others aren't entirely soundly based, but I've always chosen for that reason.
Is this quoted in your case? Is the passage you're about to look at quoted in the case?
In part, I'm going to take you first to Lord McNair, which is quoted in part at paragraph 48.1.
Which page is it?
It's bundle 8,
Yep.
tab 81,
Yep.
electronic 11829.
Thank you.
I go here because this was I think Lord McNair was relied upon by Lord Wilberforce in Nissan, if you recall, in that passage. And you'll see he draws the distinction in the first paragraph of that article
between the plea or defence called Act of State, A, and the rule excluding certain acts of the Crown from justiciability, B. So he's on the Lord Wilberforce distinction, in essence, and it may be that's why Lord Wilberforce found it attractive to cite him, but you will see what he says in relation to the plea or defence called Act of State, in other words, A, so it's a slightly fuller analysis and treatment, ultimately relying on, basing itself on Burren and Denman, Johnson, Pedler, and that line of cases. But he characterises that first conception as being a defence to an act tortious or criminal committed abroad by a servant of the Crown against a subject of the foreign state or his property, providing the act was authorised or subsequently ratified by the Crown. That's the principle he derives from the cases, and then distinguishes that from the second of the rules. So that's the source, if you will, in the academic writings of Lord Wilberforce in Nissan. And then if you put that away and go back to the more modern authority of Dicey, Morris, and Collins.
Before you leave it, how does he deal with what he calls the justiciability limb? Does he confine it to the no tools or inherently unsuitable situation, or does he speak more widely?
Well, he treats it as being rather broader, as you see from 11830.
11830.
Yeah, if you look under B, so he's, the division, as it were, is between the tort defence, which he analyses in that way, we've just seen, and then B on page 11830.
B.
Just see the first sentence under the rule excluding.
What, wider and more fundamental?
Yes, it looks like he's treating it as being akin to the exercise of the prerogative in the sphere of foreign affairs.
So it's rather the Lord Pearson approach.
Looks like it.
Yeah.
But again, one needs to be a little careful before taking too much out of it, because, as you will be aware, at the time that Lord McNair was writing, the royal prerogative as a subject matter was outside the purview of the courts entirely, and was treated in that way. So I don't want to build too much on that, but he's certainly not restricting it in terms.
This was pre-Banku, effectively.
It was pre-Banku, and it was pre all those other authorities that say just you can't turn up as the government and say prerogative.
No.
You have to demonstrate that the subject matter itself within the prerogative is unsuitable. It's that line of culminating in Abbasi. So I don't want to build too much on it, and one needs to be careful about the history of it. Yes, my attention is drawn. Can you just sideline if you're still there? Sorry, in relation to the defence, he comes back to it under the Crown Proceedings Act, 11834. That final paragraph on the page, it is suggested. And sorry, in the previous volume of authorities, volume 7, Dicey and Morris and Collins, 11671 if you're on the electronic. Otherwise it's bundle 7, tab 71. Yep. And the relevant paragraphs for our purpose are 11671 to 2. You see the title, Act of State, at paragraph 5/043. You just cast an eye over those two paragraphs, if you would, treating it effectively as a defence.
Yes, I see.
You'll see how the learned editors conceive the defence in the third sentence of 5044. Defence can be raised in regard to an act performed outside the United Kingdom and its colonies.
5043 and 5044, again, Lord Wilberforce is two.
Exactly so.
Thank you. And then 5045 is what we've had in the last case.
Yes, sorry, and just while you're there, could you also sideline the description of the facts of Burren and Denman? You'll recall the way that Dicey and Morris is set up, and they give examples of facts that cover act of state or that are within the concept. If you go to page 11679, and you go to page 5, paragraph 5057, under the heading Acts of State, halfway down the page.
Yes.
Burren and Denman is para 23.
Yes.
It takes it much further, but they recite accurately the facts of Burren and Denman. So we respectfully submit the punchline of... Yeah. Punchline of all of this, we respectfully submit, is that Mr. Justice Leggett and the Court of Appeal were correct to reject the arguments of the claimants that the doctrine of Crown Act of State is solely a rule of non-justiciability, strictu sensu, and right to reject their argument that Burren and Denman, on a proper analysis, was decided on the basis of the non-justiciability limb in that sense. It wasn't. And the reasoning of the Court of Appeal in that respect is at paragraph 332 to 341 of their judgment, and the reasoning of Mr. Justice Leggett to the same effect in the Ramatulla judgment is at paragraphs 202 to 209. I turn then to the tort defence, having sought to establish that it exists on the case law, it's been acknowledged in repeated cases in the House of Lords and other tribunals, it's acknowledged in the old academic writings, it's acknowledged as correct and as a defence and operating in that way in the more modern writings, authoritatively in Dicey and Morris by way of example. But just turn to the tort defence more generally and to its reach and scope, trying to address it rather more as an issue of principle. You will have seen from Lord Wilberforce in Nissan that the principle that they espoused as being within the tort defence was expressed at a tolerably high level of generality. And in particular, that defence started with the quote. Do you remember, if you go back to Lord Wilberforce at page 9099 in Bundle 1, it started with the quote from Professor Wade's British Yearbook of International Law adopted by Halsbury.
Yes.
Albeit with the caveat that then followed. That was the quote that Lord Wilberforce regarded as being at least at the base of the principle, and it's at least of some note that Lord Wilberforce cites that with evident approval. Lord Reid, if you go back to his judgment, cites exactly the same passage with the, I think, omission of a couple of words at the back end, but Lord Reid cites exactly the same quotation at 9080 at the letter B.
Yes.
One definition which has been accepted in some quarters is that of Professor Wade. Do you see that?
Yes. And he doesn't like it entirely.
Well, my Lord puts it that way. I will put it slightly differently, if I may. It is true that he subjects it then to some critical analysis and says it doesn't quite do the job because you need to tinker with this bit, that bit, and the other bit of the, for various different reasons in the passage that follows, as you see. But none of those criticisms, or perhaps put it the other way, all of those criticisms are in favour of, as it were, tightening the various elements within the definition. His critical analysis is therefore in no part to deny the existence of the core-based principle. He just says it needs to be tightened in various ways.
Yes, one way is, which is quite important, is or against a subject of the state.
Yes.
We see that in a number of places.
Yes, and in some respects he might look to expand it. Look at the letter D on that page.
Yes.
So, I mean, the core point is that for various reasons he doesn't much like the sufficiency of the definition, but none of those criticisms are in any way suggestive of the idea that he doesn't like the base concept. They're all to do with tightening to try and make it work better for the purpose for which it exists. And for good measure, in terms of the quotation of that bit, at least as a starting point, that passage from Professor Wade, Lord Morris, who also has various things to say about it and in part doesn't much like it, and is perhaps a little closer to not liking it than Lord Reid, he starts from the same place, 9086, at the letter E.
Yes.
And then so that's the starting point, and then he goes into the analysis which we've seen over the number of pages. Of Burren and Denman and the scope of the doctrine and all of that. But he starts with that base conception, that base quote. So they all like that quote as the basic idea that underpins it. And so the question then, if that's the starting point, if that's the base, because we know that Lord Wilberforce went on, and so do some of their other lordships, what flavour does one get about the possible reach and limitations of the tort defence from the judgments? We know that all except Lord Reid based their decision on the fact that it wasn't an act of state in this case because it was too distant from the provision of troops or the engagement in military operations. But it is, we respectfully submit, implicit in that reasoning that it might well have been different in their lordship's conception of that principle if, for example, you were in fact implementing a treaty. It might be different if, for example, you were closer to that hard core of sovereign acts jure imperii, to military operation, to necessity of conducting military operation in a particular way.
The only significance of implementing a treaty must be that it's actually prior approval. You don't need ratification if you're acting under a treaty.
Yes.
Because it doesn't have any domestic law effect.
Yes.
What would the position have been in Nissan if the Attorney General had put it on a wider basis, the Secretary of State having formally ratified the act of British troops in taking over the Corona Hotel? Now, do you submit that in that situation, leaving aside the problem about the nationality of the owner of the hotel, act of state would have run? I think you have to, don't you?
Yes, I think we do have to accept that. I mean, the only reason I'm pausing is because it is possible to see this doctrine as a doctrine which is judicially created and judicially controlled, so that if one were to make the example extreme, as it were, then I can see that the further away one got.
Well, unless it boils down to a question of judicial discretion, which is rather an unattractive way of looking at it, it's hard to see how that can make a difference. In principle, I think you've got to say the Crown could have ratified this particular appropriation, and then, if the Attorney General hadn't confined himself to this being the natural consequence of a non-justiciable treaty,
Would have had a Burren and Denman.
The result would have had to be different.
Yes. I mean,
Is that right? I mean,
I'm just sorry.
I share your doubts.
Yeah, well, I'm just a little concerned about the idea that, I mean, you don't necessarily jump from it being a principle which is fundamentally dependent upon ratification to it necessarily being, as it were, outside the purview of the court and therefore subject to pure ipsi dixit.
It's outside the purview of the court, but if it's being a defence.
Why wouldn't it be, if Burren and Denman is right?
Well, because the argument against it being, as it were, a complete answer is that this is a creature of the common law, and of course the court would pay very careful attention to that ratification or that view of the executive, but it wouldn't necessarily be conclusive.
But your whole case has the proposition that it's got to be a certain, both limbs of Buren and Denman, as they are seen, have to or depend upon identifying a sufficient sovereign act. And if it was just a municipal act, which this was treated at, it wouldn't be capable of being made a sovereign act by ratification, would it? I mean, this is slightly new territory, but...
It's slightly new territory, but I mean, I with respect, I share the concern. I don't want to overstate it, because one can then posit more and more extreme examples of things which perfectly obviously wouldn't have the...
I mean, Pure and Denmark's an easy case. It's a sovereign act, effectively, except that the sovereign wasn't behind it at the time.
It has to be of that nature. And when I come to the conditions...
Why is it an easy case? Why? Sorry, I shouldn't ask.
Wait. Can we discuss it afterwards?
I'd just like quite to know, what is the principle which you identify as supporting the answer that you gave to my Lord Neuberger a moment ago? I mean, I can understand why, forensically, you might regard some of the outer reaches of the doctrine as unattractive, but what's the principle that entitles you to say that if, for example, the Crown had in advance authorised the taking over of hotels, that would have been outside the doctrine? Because if the Crown had authorised it in advance and it would have been outside the doctrine, then on the face of it, if they ratified it in arrears, the result would have been the same.
Well, my lord, I think the conception that we advance of the doctrine is that it involves something which is properly to be characterised as a sovereign act.
Yes. But why wouldn't it be a sovereign act if the sovereign had authorised this thing to be done outside the United Kingdom by her armed forces?
Well, if you're in that territory, then I can perfectly sensibly see that would fall within the principle that there isn't some form of freestanding discretion in the court to say, no, we can ignore that or disagree with that. The boundary that I was flirting with, if that's the right way of describing it, is that I wouldn't, I think, go as far as to say that this is a doctrine which is solely outside the purview of the courts.
But if the test was urgent military necessity, then if it felt authorisation of the hotel or no authorisation of
wouldn't make any difference.
It wouldn't make any difference.
It wouldn't. It wouldn't come within it.
But was it urgent military necessity in Bjorn and Denmark?
Well, I think that's simply being put to me as an example, rather than as an expression of the totality of the principle.
So what you're saying is the mere fact that there's formal sovereign approval either in advance or through ratification isn't enough. It's got to be a certain type of act.
Yes. It's got to have
what type of act?
Well, let's start with what on my submission, it undoubtedly covers, which is the conduct of military operations and matters that are necessary to that.
All military operations?
Military operations abroad, I'm not...
So would it cover the sending by the armed forces here of a drone abroad in order to kill somebody, let's call them an alien, but of course it could be a British subject as well, abroad?
Well,
would it cover that?
My submission is it would. It would. That would be classically a sovereign act, jure imperii.
So if they had blown up the hotel, would you have been entitled to say, well, they blew up the hotel, it was a military operation in any sense of the word, but actually, if they'd been a bit more careful about it, they would have realised it was unnecessary to blow it up? Would that have removed what would have been the impact of that on the liability of the Crown?
Well, if it formed, is my lord assuming that in those circumstances the blowing up of the hotel is ratified afterwards?
Well, I'm just trying to test the suggestion that inherent or immediate military necessity is a helpful definition. Let's suppose that they had, by an honest mistake, unnecessarily blown up the hotel with tank fire. Now, and let us suppose that that was ratified after the event. I think the principle for which you're contending says that whether it was strictly necessary to blow it up or not, that was a sovereign act. The difficulty that I then have is in what sense, apart from its being less drastic, is it different if one ratifies the taking over of the hotel? Let's suppose that it was taken over for the purpose of having good vantage points for some building a bit further away. I just find that once you depart from the concept of ratification as being the key that unlocks this doctrine, you're in a complete no man's land. Now, that may make it easier for you in the sense that it gives you a clear definition. On the other hand, it may make it more difficult in the sense it may be less attractive.
Because more is covered.
Yeah.
My lord, yes. And my answer to
anything is
that,
covered.
I think, in principle, is that it's somewhere betwixt and between the two. You of course need the certainty
which it is.
Yes, but you of course need the certainty of the principle. And what I'm not suggesting is that, as my conception of act of state, as it were, one gets involved in the intricate judgments about military necessity.
No.
Is it necessary or not? But what I'm nervous about, the underlying and remaining nervousness in my mind, is that if you had an act which had absolutely nothing to do with anything, to do with the military operations, but the Crown nevertheless, as it were, came along and ratified it, whether that would be enough. There is something about the nature and quality.
Ratification isn't really the point, is it?
Ratification equals
Authorisation.
authorisation. And suppose the Crown enters into a contract relating to something abroad and is sued here, or it couldn't say, well, we authorised it and we're not liable. No. Yeah. It's got to be something about the nature.
There's got to be something about the nature and quality of the act. But I think, in fairness to my Lord Sumption, the point he's putting to me is, what is it about the nature and quality of the act? Is it enough simply for the Crown to say, perhaps take it away from ratification, I approve in advance the blowing up of the hotel, which turns out to be unnecessary. Your concern, as I understand it, is unless you can answer that question, as it were, in a straight-lined way, you end up with the principle, however forensically attractive, being too fuzzy to be upheld.
It's got to be a sovereign act, but it's got to be more than a sovereign act. One's concerned with particular kinds of sovereign act. If the RAF flies in exercises over Germany, for example, in current conditions, and negligently causes damage to property in Germany, it would be committing a sovereign act, but I don't think anybody would suggest that it was entitled to an act of state defence. And it may well be that the ingredients are, one, a sovereign act, and two, an act of force visited against the person or property who's got the claim. There may be other requirements as well, but those two things seem to be essential.
My Lord, I am going to try and define, I'm very conscious of the time, I am going to try and define what we say those ingredients are.
Would you accept the two that I've identified as being at least part of them?
Would you like to?
An act of force.
Would you like to do this after lunch?
Or whenever.
I'll try and do it after you get it.
We'll resume again at 2:00. Thank you very much. Court's now adjourned.